We are live. So, John, you can hear me? Yeah. Well, perfect. I love it when it works. Excellent. Right. What I want to do is get started. So, sorry for the delay, but welcome to Module 2, Principles of Criminal Law. We're going to look at the objectives. We have three objectives. I thought I'd add a little bit more to this presentation besides just discussing the assignment. So initially, we're going to explore the crime categories and rates. Next, we'll review the Module 2 assignment. And finally, I'm going to share some resources that might help you complete your assignment. So let's start by looking at the categories of crime. We have two general types of crimes. We've got the felony and the misdemeanor. On this table, you can see the comparison between the felony and the misdemeanor. Felony, as you might imagine, is more serious than misdemeanor. In terms of punishments, they'll probably be spending 1+ years in the prison and hopefully not on the death row, but some will go there. If you committed a misdemeanor, you'll generally stay in the local jail. If you are incarcerated, if you committed a felony, you will be in either a state or a federal prison. And you may start in one prison and later be transferred to other prisons. If you're a misdemeanor, you're strictly the local jail. Types of felonies include, you can see the list there. And then misdemeanors, you have the list for the examples. Okay, let's look at crime rate by state. We see both the highest crime rates and the lowest. And then you have a map showing the crime rates throughout the country. John, what state do you live in? Wisconsin, great place. Great place. I love Wisconsin. I used to go camping in Wisconsin. And Wisconsin's not the lowest crime rate, but it's not the highest crime rate either. So we're doing good in Wisconsin. I found this, I thought it was really interesting in terms of violent crime rate. We're going down, but if we look at 2021, it was a major dip. The dip in America's violent crime rate in 2021 can be attributed to a combination of social, economic, and law enforcement related factors following COVID. Let's look at the 10 cities with the highest crime rates in the US. And it's not Chicago, guys. Detroit. Yeah. Do any of these surprise you? It's nice to see we've got more property crimes than we have violent, but still, we still have violent crimes. Now, when I think about this and they're saying that the crime rate's decreasing, I find that kind of hard to believe because we have on every evening newscast, we report at least one violent crime. Now we're going to move to a question. How safe is your community? Or what is your community's criminal activity? We have 2 steps to take on this. I'm going to ask you to submit your answer to the Module 2 live classroom, and that will be worth 5 points. And then we have an optional place to post your response. Please share your response in the third course community. I tried to rename the course communities so we wouldn't have to work it this way, but it's not giving me the authorization to change the course community name. So it's going to be the third one down. I encourage you to post your response in both places. If you come over to the course community, you can share your thoughts with your colleagues. It's not required and it's not worth any credit. The only place it's going to be worth credit is in the Module 2 live classroom. And when you do, whoops, wait a minute. Just advanced on it. Hold on. Let me get back. Okay. When you respond, please use a college paragraph. And the college paragraph rule of thumb is 5 to 8 sentences, or approximately 100 to 200 words. Focus on a single distinct idea explained and supported with evidence. Begin with a clear topic sentence that introduces the main idea. Develop the idea with evidence, examples, analysis, and finally end with a concluding sentence. So we'll write about 100 to 200 words, one paragraph response. Next, we're going to look at the assignment, which is Module 2 Criminal Statute Report. We have to set the stage. In this scenario, you will be acting as a new patrol officer. Your field training officer has given you a task to demonstrate your understanding of how to locate a criminal statute in order to make an arrest and charge someone with the crime. Let's glance at the instructions. Top down, we see the little video, we see the scenario and the instructions. Look up 5 crimes. We could click on one of those links if we have problems finding our state statutes. So those links lead directly to like the New Jersey state statute or the Minnesota state statute. And then we have the items that we need to address for each of the 5 crimes. And then you conclude with a paragraph. And that's item number 4. Now, I encourage you to listen to this short video. He did a great breakdown as to what you should complete. So I let you play that on your own, but it's inside our course. Okay, now we're going to go back to the instructions. Just kind of look this over, focus on points 1 through 4. And those are the New Jersey and the Minnesota state. Those are all hyperlinked. Okay, now we know what we're going to be doing. Let's look at the grading rubric. I encourage you to look at the mastering column. You can see how many points each item's worth and what you should be doing. Now I'm going to focus in each of these and say a little bit more about each section. There is a note down at the bottom of the slide, and it says APA 7th edition formatting. Please remember you must use the APA 7th edition formatting when completing your assignments. I let you kind of, I didn't pay attention to the APA formatting when you came to the E. But when we're writing reports or creating a PowerPoint, we should always use APA 7th edition formatting. And Rasmussen University Online Library offers a wealth of information about how to apply APA 7th edition formatting. Okay, so now we're back to the instructions, and we're going to go step by step. And I'm going to be using New Jersey as an example. So let's look at the elements of a crime. We have 3 elements. And you'll notice that some of the things that I'm going to be using in this slide, I screen captured them from the content that's in our online class. So we've got actus reus, mens reus, and then concurrence of the first 2. What I'd like to do next is look at actus reus and mens rea in more detail. So this is from Law Shelf.
To be found guilty of a crime, the prosecution must prove that there was a physical action, actus reus, and a state of mind to commit a crime, known as mens rea. Mens rea is concerned with what the defendant was thinking at the time he committed the actus reus. Different crimes have different mens rea requirements. Mens rea is divided into 3 categories: general intent, specific intent, and recklessness or criminal negligence. Additionally, there is a class of crimes for which no mens rea element is required. These are called strict liability crimes. Strict liability crimes are crimes for which liability is imposed without consideration of the defendant's knowledge or intentions. First, we'll begin with general intent. General intent crimes require that the defendant had the intention to commit an illegal act. All that is needed for a conviction is an intent to commit the act that constitutes the crime. General intent exists when the illegal act may reasonably be expected to follow from an offender's voluntary act, even without any specific intent by the offender. To prove general intent, the prosecution must demonstrate that the defendant acted intentionally, in the sense that he was aware of what he was doing. For general intent crimes, the very doing of acts that have been declared criminal shows the criminal intent necessary to sustain a conviction. For example, a defendant can be convicted for the illegal skinning of an alligator if he is merely in possession of an alligator that was not appropriately skinned. This is because a jury may infer the required general intent merely from the doing of the act. Some examples of general intent crimes are the following: rape, battery, false imprisonment, and kidnapping. Now we'll look at specific intent crimes. Specific intent designates a special mental element that is above and beyond any mental state required with respect to the actus reus of the crime. Specific intent is a term used to describe a state of mind that exists where a defendant objectively desired a specific result to follow his act. The prosecution must prove that the defendant acted with the intent to achieve a specific goal, as well as the intent to commit the illegal acts. Specific intent cannot be inferred from the commission of the act, and specific proof is required to demonstrate that this element is satisfied. Conspiracy is an example of a crime requiring the mens rea to be specific intent. The General Federal Conspiracy Statute provides, if 2 or more persons conspire to commit any offense against the United States, each shall be fined not more than $10,000, or imprisoned not more than 5 years, or both. The specific intent required for the crime of conspiracy is in fact the intent to advance or further the unlawful object of the conspiracy. Other examples of specific intent crimes are attempt, assault, first-degree premeditated murder, burglary, and false pretenses. There are also crimes that require neither specific nor general intent. A prosecutor can secure a conviction by demonstrating that the defendant acted recklessly or negligently. Both recklessness and criminal negligence may exist when the defendant acted with a gross lack of care without paying attention to the unjustifiable risk that the circumstances exist or that the result will occur. Recklessness is a higher level of guilt than criminal negligence. Both negligence standards and the possible criminal charges stemming from criminal negligence vary state to state. Even though there are variations, the defendant's mental state must be of such a nature and to such a risky degree that the failure to perceive the risks of his actions constitutes a gross deviation from the standard of care that an ordinary person would exercise. Unlike general or specific criminal intent, criminal negligence is negative, meaning it does not require an affirmative act by the defendant. An example of a conviction based on a showing of recklessness occurred in a case involving drag racing. The defendant was convicted of negligent homicide as the result of illegal drag racing, where speeds were at least 40 miles per hour over the speed limit. After two vehicles engaged in such reckless driving, there was a crash and a fatality. The prosecution successfully proved the defendant's mental state was reckless. In convicting the defendant, the court reasoned that driving at those speeds while drag racing exhibited such disregard for the interests of others as to amount to a gross deviation below the standard of care expected of a reasonably careful man. And now we approach strict liability crimes. Strict liability crimes, also known as public welfare offenses, are crimes that do not require mens rea. The defendant could be found guilty merely because he committed the act. Some examples of crimes that fall into the strict liability category are statutory rape, selling alcohol to minors, and in some states, bigamy. Statutory rape is a strict liability crime because even if the offender believed that his partner was of consenting age, he is still guilty of committing the crime so long as the victim is under a certain age. These laws, even though very severe, are intended to protect certain classes of individuals from certain kinds of conduct. Determining whether a crime is a strict liability crime depends on the state legislature's intentions.
Now we're going to look at the New Jersey state statute. And if you look at that blue arrow, it has text in red. It says, view our newest version here. So I clicked on that link. And now I have the newest version. And if you scroll down on this page, you have that link inside your course. So if you ever use it, you come here, you're going to find out that this page is really long. Now, let's say you want to find burglary. So I entered burglary in the search, and I found 3 occurrences. At that time, I would click on the top burglary and go in and read the elements of the crime, which is here. Now, since we're just kind of working with this, perhaps this is your first time, go easy. Focus on the main points, points 1, 2, and 3. Point 3 has multiple layers to it, but we're just kind of looking at this for maybe just the first time. Next, we're going to show you an example of burglary. In this video, you'll hear about 4 things: common law elements, the model penal code, recent developments, an example of burglary. Now, before we start the video, ask yourself, what is the model penal code? The model penal code is a series of criminal law rules written by the American Law Institute as a model for how they suggest states enact their criminal laws. Okay, so since it's only a model, it's not a requirement, my next question was, how many states use the model penal code? According to the figures I found, at least 37 states have adopted at least some of the provisions of the model penal code. So watch this video.
Our understanding of burglary has evolved greatly as our society has changed. Some scholars even argue that burglary should no longer be considered a separate criminal offense. Every state has its own rules for burglary, and they vary widely from state to state. In this presentation, we'll analyze the common law elements of burglary, the model penal code's approach to burglary, recent developments to burglary, and a comprehensive example of burglary. The required historical common law elements are 1. A breaking, 2, and entering, 3, of a dwelling or house, 4, of another, 5, at night, and 6, with the intent to commit a felony therein. Breaking requires that some force be used to enter the house. Entering requires that part of the burglar's body pass the threshold of the house. Originally, a dwelling or house was limited to the physical home of a person. Next, common law burglary must have been committed at night. Daytime breaking and entering was the lesser crime of trespass. The of another requires that the burglar break into someone else's home, as a person cannot commit burglary in his or her own home. Finally, the burglar must intend to commit a felony once inside the dwelling. This is usually theft, but can also include intent to commit other crimes, such as murder, rape, arson, or assault. Since these definitions were created, states have broadened, eliminated, or modified them extensively. Let's take a look at the Model Penal Codes approach. The Model Penal Code is a series of criminal law rules written by experts in criminal law as a model for how they suggest states enact their own criminal laws. It contains suggested statutory language and comments to help states codify criminal law. The Model Penal Code has been adopted to some extent in some states. The comments of the Model Penal Code indicate that the drafters considered eliminating burglary as a separate offense, because punishing it more severely than trespass and theft was harsh and irrational. The drafters of the code believed that the law concerning the crime attempt, as in attempted theft, now encompassed actions that were traditionally thought of as burglary. However, the drafters believed that burglary was so deeply embodied in American law that it could not easily be discarded. Under the Model Penal Code, the required elements of burglary are 1, a person entering, 2, a building, occupied structure, or separately secured portion thereof of another, and 3, with the purpose of committing a crime therein. These elements apply unless the premises are open to the public, or if the person is licensed to be there. The Model Penal Code's approach to burglary significantly broadened the scope of actions that could be considered burglary. First, the burglary no longer must take place at night. Second, the burglar doesn't have to break anything to get in the house. Third, the crime committed inside does not have to be a felony. The extent to which the Model Penal Code's approach to burglary has been adopted by the states is mixed. Like the code suggests, most states have eliminated the common law elements of at night and the breaking requirement. Also, many states have broadened the definition of occupied structure to include any property owned by the victim. Lastly, many states provide that a burglary occurs if any crime is committed inside a structure. However, states' laws vary on whether they require an entry, if the structure must be a dwelling, and if the dwelling must belong to another. The following example will compare the common law approach to burglary with the Model Penal Code approach. Let's look at the following facts. Ben recently turned his storage unit into a high-tech man cave and wants to show it off to one of his best friends, John. Ben invites John to watch a baseball game in the man cave at noon. When John arrives, Ben opens the storage unit's door and beckons John to enter the man cave. John sits down inside and they watch the game. After the game, Ben asks John to leave, and John does. John makes it to his car, turns around, walks back into the man cave, and grabs 83 cents worth of loose change that was on a side table right at the entrance. He takes the change from in front of Ben and runs away. First, let's look at the common law approach. John could not be convicted of burglary under the common law. John did not break into a dwelling at night, and he did not intend to commit a felony, as stealing less than $1 is a misdemeanor, not a felony. For John to be convicted, the following facts would have had to have been different. First, the man cave must have been in Ben's house. Second, John must break into the house. Third, John must intend to commit a felony, such as assault, and not a misdemeanor, such as petty theft. Fourth, John must have taken these actions at night. Since John did none of these things, he could not be convicted of burglary under the common law. However, John could be convicted of burglary under the Model Penal Code. First, John entered an occupied structure, in this case, Ben's converted storage unit. Second, while John did not have to break into the man cave, he did have to enter uninvited. Once John left, he no longer was an invited guest and could only re-enter the structure as a burglar. Finally, John must have intended to commit a crime in the building or structure. Here, John entered Ben's man cave with the goal of taking 83 cents worth of loose change. Thus, he could be charged with burglary. State approaches to burglary offenses vary, depending on what elements a jurisdiction's statute has adopted. Some steadfastly adopt portions of the common law. Some embrace the model penal code's take on burglary, and others go far beyond either the common law or the model penal code. No matter what elements are needed, the intent of what burglary seeks to prevent remains clear and evident.
Okay, let's go on. What to include? If you've been inside our course shell, you'll know that this is taken from there. So we're looking at the state statute number and title, the statute language, the elements of the offense. You can see that we're not writing a lot of information for any of those, only what will help us know that we have reviewed that statute. I have an official recommendation. While unofficial, electronic versions of codes may be available and helpful, it's crucial to consult the official state-sanctioned versions of the law when accuracy is paramount. So if you were an actual police officer, you would want to use the official code. The official status of online legal information can sometimes be difficult to determine, in which case contacting the responsible governmental entity is advised. You can also find information about the official status of online legal information on a state-by-state basis from the American Association of Law Libraries State Online Legal Information site. So that's one possible source you might use when you're completing this assignment. Now, we're supposed to be talking and identifying whether or not this is a felony or a misdemeanor. And remember, we're using the example of New Jersey. And based on that, I found this that was kind of interesting.
Many times clients contact my office and ask about the difference between felonies and misdemeanors in New Jersey. First of all, we do not have felonies and misdemeanors in New Jersey. We have different terminology. A felony is known as an indictable offense in New Jersey. This means that for the case to move forward from a complaint to an indictment, the case has to be presented to the grand jury. So that's why it's called an indictable case. But this is the equivalent of a felony. On the other hand, misdemeanors, we don't have misdemeanors, they are known as disorderly persons offenses. Petty disorderly persons and disorderly persons are two types of misdemeanors that we have. They are the lowest level criminal offenses we have in New Jersey, and they will be prosecuted in municipal court. So, misdemeanors handled in the lower court, municipal court, they'll usually be an arrest, and you will usually be released on a summons with a court date. The only exception typically is on domestic violence offenses. On those cases, you will be arrested and there will be a warrant issued and you'll have to go to the jail. On the other hand, for indictable or felony level charges, a lot of the charges will be processed on the warrant and you will have to go to the jail. Then the judge will determine whether or not your bail should be granted and what conditions should be placed on your release. The most serious felonies we have in New Jersey is a first-degree charge. On most first-degree charges, it's 10 to 20 years in jail. There are certain exceptions to those rules, like kidnapping, carjacking. Some of them are enhanced to 30 years, but the basic range on a first degree is 10 to 20 years. On a second-degree charge, which is the second most serious indictable felony type crime we have in New Jersey, you're facing 5 to 10 years in prison. On a third-degree felony, you're facing 3 to 5 years in prison with a presumption of no jail time for first-time offenders. This is a very important distinction. First-degree and second-degree charges, it is presumed that you will be sentenced to prison even if you have no prior record. third degree and fourth degree felonies, lower level felonies, it is presumed that you will be sentenced not to jail, but to probation if this is your first time felony conviction. Lastly, fourth degree felonies, lowest level felony we have in New Jersey, you're facing up to 18 months in prison. Disorderly persons offenses, that's next. That's a misdemeanor. You're typically facing a $1,000 fine and up to 6 months in the county jail. And lastly, petty disorderly persons offenses, $500 fine, 30 days in the county jail. If you have additional questions or need more information, contact my office anytime for a free consultation.
Okay, and now we're going to move to explain the features of each crime. The who, what, when, where, and why of the offense. Let's look at an example. This is taken from your online course. You can see the state statute, the statute language, elements of the offense, category of burglary. We are recognizing it as a felony in some states. Not all states, because we just watched a video and New Jersey does not use the term felony or burglary. And then we move to the features of burglary. Here's elements of burglary in Wisconsin. John, you might like this one. Gives you the breakdown for burglary. And then some final thoughts. After we finish getting the top characteristics of the crime, we need to write a paragraph briefly explaining why the application of criminal state statutes is important for exhibiting principles of ethical conduct and professional behavior. So after you've identified all the top requirements for the given crime, you will write one paragraph based on that specific crime. And that will be the first part. Remember, we have to identify 5 felonies. So we have to follow this process for each of the 5. Now, there are plenty of online resources, and we already noted that if it's official, we've got to make sure we have the official standards. But since this is for a class assignment, we can use the ones that help you the most. So I'm going to share some resources with you. The first one is the Legal Information Institute. And this is just their welcome page. I'm providing links to each of these resources in our course announcements. I'll be uploading a PDF file of this presentation, the recording, as well as links to some resources that might help you. All right, the next one we're going to look at is the Legal Information Institute listing by jurisdiction. So all jurisdictions, all states are listed on this one page. Another source that you might like is the CRM 101 Basics of Criminal Law. This is actually a 3-credit course, which is free to use. I noticed something. It states that this course has been evaluated and recommended for 3 credits by the National College Credit Recommendation Service, or NCCRS, and may be transferred to over 1,500 colleges and universities. So maybe if you're interested, you might want to contact the registrar's office and ask them if you could earn 3 college credits for completing Basics of Criminal Law. You will have the link to this class, but always check first with the registrar. Make sure the credit will transfer over to where you want to graduate. Next, we're going to look at some list of criminal charges A to Z. We're looking at crimes against the person, homicide, property crimes, and sex crimes. And what I did is I identified the index crimes. There are actually 8 index crimes, but at this site, it did not include motor vehicle theft or arson. But it does have information about all these. So maybe this might be one source you can use. And this is a complete list of all the crimes that are focused on at that site. So you can see that there is a lot of information. Next, we're going to look at the Real-Time Crime Index. It's data obtained from the FBI Uniform Crime Report, UCR. Why the Real Crime Index does not show arson. Arson is difficult to assess nationally due to underreporting, inconsistent agency data, and challenges in determining causes. So out of all those major crimes listed, you will not find arson. Once you get to that site, they do give you information if you scroll down. And one piece of information would be how to use this site. And here's an example of how we're doing right now in terms of some of the major index crimes. By looking at the change column, you can see that we are decreasing in all of these. All right. Now, summary. We've explored the crime categories and rates. We reviewed our assignment, and I shared some resources with you. So, John, do you have any questions? Okay. Since you don't have any questions, I'm going to make sure this recording gets put inside our course shell. Stu's got chat. No. Okay, great, John. Appreciate that. Okay, so I'm here. If you need me, I come into our class multiple times a day looking to help. Thank you very much for attending this, and I'll be putting the recording in our online class. I'm going to stop now, so thank you very much for joining me. Talk to you later, John.